Just gonna wait until I see a few more commissioners jump on. Okay, so I see 6 commission members, I believe. So I guess I'll get going at this point.
Sounds good.
So welcome everybody to this afternoon's Special Conservation Commission meeting. The Nantucket Conservation Commission is convening primarily to discuss Sconset Bluffs enforcement, although we do have a moment of public comment to begin. I just want to remind everybody that since we're over Zoom, please make sure your computer or phone is muted unless you're talking. In order to be recognized to speak, please raise your hand. You can also raise your hand virtually and we can recognize you. Also take care not to screen share your computer, as anything you screen share may be captured by tonight's recording. So with that, we will begin tonight's meeting under public comment. Is there any public comment on items not being heard today? That's kind of what I anticipated. So at this point, we will begin the enforcement discussion for Sconset Beach Preservation Fund, 87 through 105 Baxter Road. And this is for SE 482824. So we left off, I guess that was early August was our last discussion on this. And we are picking back up at this point. So Jeff, I don't know, you sent out the draft enforcement to everybody yesterday, I believe. So commissioners should have gotten that. We've also received a few letters. Margaret, do you have a public comment?
Yes, I'm a little confused by what you said at the top. Is this when we're supposed to speak, or are you doing that with us at another time?
So that was public comment, just general public comment. Members of the public who wish to speak on the Sconset Beach Preservation Fund issue will have time to speak after the commission has discussion.
Okay, so I should wait till then.
Yes.
I appreciate the clarity. Thank you.
You're welcome. So at this point, the commission has really a few options. We can discuss the removal order that was sent around. We can also discuss, other options like, speaking to the select board in a formal meeting, or, amending our enforcement to, include different mitigation components. So we have a few options in front of us this evening. And I don't know if any commission members would like to speak to maybe Jeff's draft order of removal first, or any other issues. Jeff?
Sorry, I apologize for hopping in now. I know we're waiting for commissioners, but just also as a reminder, one of the purposes of the discussion too is obviously the last meeting. We did hear from town council in the role that they're able to play in this, as far as review and what they've been authorized from the select board. I know people wanted some time to kind of think about that and soak that in. So if people have other questions about their continued role or not continued role, or how they wish to proceed, I think identifying those issues is always a good idea as well. But I know that was part of the conversation.
Thank you, Jeff, for that reminder. So commissioners.
I have my hand up there somewhere. It's still new to me, Zoom.
All right, we got to get you on camera, Linda, for next meeting.
Never.
Go ahead. Yeah, I think we got to do it. But go ahead.
I hate to be blunt about it, but I don't know why we're having this meeting today. My preference has been all along that we should have a formal meeting to at least acknowledge the selectman's letter, have a formal joint meeting where the both are posted. I know some are watching here today. And there was some question about a comment another commissioner made. Well, they had any opportunity to speak. No, they don't. They can't speak individually and they can't congregate themselves here to talk about material issues that they're dealing with because they might violate the open meeting law. So I think we need to, before we do anything, and I'm not in favor of this enforcement order that Jeff has drafted. And I think we need to meet with the selectmen. I have other comments as well, but I'll get to them as we get into this. But I think we need to meet with the selectmen in a formal joint meeting and lay everybody's cards on the table because they do have a bigger picture. I do understand that we have to enforce the state and local regs. But as far as I can tell, there has, especially from reading that report that came to us from Woods Hole, the 85th review, I believe, I don't see any detriment. Nothing's gotten worse because those geotubes are there. Obviously, there's enforcement issues with their violations, some of which I understand because I went over a lot of them today, were minor, correctable, and not a big hoorah, to use a local phrase, that could be worked through. I still have a problem with the amount of sand that we're requiring, et cetera, et cetera. So I think all of those things vis-a-vis their letter today, 18 pages of it, could be worked out with them. My question to staff through you, Madam Chairman, is how do they get back to us? Do they have to file a brand new application? Do they file a modification to the original order? How do they formally get back to us to consider their letter from last month and their letter that came today? I don't know how that process works, especially after you guys took a vote in June to remove them. I don't know how your process works. I know how others do. I do know that we cannot motion to have a reconsideration because it wasn't done at the same meeting. So that's off the table, but how do they get back to us formally to give everybody a chance to back up a little bit and take a look at what they're proposing now?
Thank you, Linda. I appreciate those comments. The select board, potentially we could have a joint meeting with them. It was also requested of them that we participate in their executive session and we were denied. So there's, many layers to this. I do think we need to remember that our purview is upholding our local bylaw and state regulations. And this project has been in violation of its permit for years now. And that's a really, really major issue. And despite kind of back and forth that might differ, this is really the only project to my knowledge that has acquired enforcements like this. And this project actually has failure criteria that they've met, which again is a very big deal. So, I recognize that there have been letters that have come in after the fact, but we have to move on with our process at some point, and that's what we're doing today. Jeff, I don't know if you can speak to any other of Linda's questions.
Before Jeff answers, Madam Chairman, I just want to reiterate that I understand what our purview is. I also understand that if something's being detrimental, we have even more incentive to require fixing that problem. This has so far not been detrimental. I understand this is a football. It's been going back and forth since 2014. Some of these violations that we mentioned are minor, that were fixed.
So, Linda,
I'm just curious.
Linda, I don't want to interrupt, but we've been working for years with this applicant, and they aren't minor violations. They're failure criteria violations. I mean, there was contaminated material dumped on the beach. That's a big deal. That was a large volume.
That's also untrue, but that's a different issue.
Right.
Yes, I have read that. I know I remember hearing about it at the time, and I know the same sand got dumped next door, et cetera, et cetera. So I don't want to relitigate those issues, but I say some of these other issues, like missing a reporting issue, I believe Josh was sick from what I understand. They can fix the ramp issue. I still think the sand mitigation has to be discussed and adjusted. So I think there are other things that we could work with them and the selectmen if we back the truck up. But I'm just finding, I just need to know technically, how do they come back to the Concom since we can't reconsider your vote? Do they have to make a brand new application or a modification of the previous COA, order of conditions?
My understanding is they could file a new application for a project of their liking. Jeff, am I incorrect in that?
At any point, any applicant can apply for any project that requires a filing. Obviously, there are rehearing questions if it's a similar project that's already been acted upon. But certainly any applicant, not, erosion projects or houses or pools or whatever people are looking to do, if it's in a jurisdictional area, they can certainly file an application.
Is it, through you, Madam Chairman, is that a modification or a brand new application?
The order of conditions on this site, Linda, is still valid. Would still be the ability to apply for either an amended order of conditions for a period of time till that expires, or if you're looking to change, obviously, something within the order of conditions first, in this case where you're looking at, a nourishment amount, I think you'd be required to file because you'd be amending that order of conditions and not simply just doing a modification to the scope of work. It's not like you're, switching, clethra for viburnum, or, I'm going to slide my pool 2 feet to the left. So this is a little bit more significant and it directly ties to conditions. So I think any change of that volume would require an amended order at a very minimum.
I think that's what I was after. We used the word modification at the other two boards. So this is an amended order then.
Correct. And that would have its own independent hearing process.
Right. I figured we had to go to public hearing for that stuff.
Yes.
Correct.
And they know they've had the option to amend the order if they've been upset with the sand volume. And they never went through that process. So.
And
Right.
plus, I'd like to wait for Arcadis, but that's a personal preference here.
Thank you, Linda. Any other commissioners' comments? Okay, if not, I say we get into the nuts and bolts of the order to remove and look through that. So Jeff, I don't know if you want to pull up to screen share that document.
Sure, just give me 1 second. I just opening it, and I know for screen sharing, I just want to make sure that I have the YouTube chat put somewhere else so it's not on the screen. So
Some people have reported that the Concom is not up on YouTube. Has that been corrected?
I will double check that as well. No, I have it, and I have 31 folks watching right now on the YouTube.
They might need to refresh their
Thank
screen.
you, Ashley. All right. Sorry, to get back. All right, so let me share my screen if people would like to. Can everyone see that?
Yes.
Do people have questions? I don't necessarily think I need to read it all out loud for everyone. So, or suggestions or edits.
No, Seth.
Thank you, Madam Chair. Sorry, I didn't know if you could see me with the screen share. Jeff, can you clarify the previous enforcement findings? I see the 3 listed. I was under the, I guess, assumption that there had been 4. There was another one in my mind in 2019 related to violation of a cease work order, but was that the same thing as the 12/11/2019, or is that 2 separate processes?
Thank you, Seth. I think you're right on that one.
Sorry, all my buttons are moved around with the screen share, so sorry about that. That was kind of wrapped up in that 12/11/2019, Seth. That was all part of that kind of same process. If you'd like me to call it out separately, I'm happy to call that out separately.
No, if there was only one like legal enforcement issue, then it only needs to be called out once. I just want to make sure we're not missing anything.
No, and it all has the same record that goes with it too. So, in minutes and such.
Thank you, Seth. Try and scroll through. So if I miss any commissioners trying to comment, just let me know, because I do have a smaller window I'm working with. I can't see you all at once. Any
If people
other?
want to see a page change too, please just let me know.
I printed it.
Ian, and then Maureen.
Thank you, Madam Chair. Jeff, I wonder whether, taking Seth's point, that in fact it should be considered another violation, because in your letter or in our letter on our behalf to the Select Board on April the 16th, 2020, what you list as violation number 3, in the letter was listed as violation number 2, and violation number 3 in the letter was, and I read from the letter, on March 27th, 2020, the conservation agent, Jeff Carlson, was provided photos of SBPF working on the nourishment template. This work was verified. On April 22nd, 2020, the commission unanimously voted that this work was done in violation of the cease and desist order in place. This work was also done prior to the discussion of the second round of testing being reviewed as part of a public meeting. This is unacceptable, and the commission is requesting that the Select Board take additional action to ensure that this type of activity cannot happen in the future. So under those circumstances, I think it should be included as a separate violation, because it in fact has nothing to do with the improper nourishment, which was dealt with in that letter of April 16th, 2020, as a violation number 2 from December 11th, 2019, as you note in your table. Thank you, Madam Chair.
Thank you, Ian. Maureen? Oh, you're muted.
Okay, sorry about that. I just wanted to say that having read the order of conditions and with the correction that Ian just outlined, I went through it to see if we've got all of the facts and our various findings, so that we have everything here in black and white that is involves what has happened here from a factual point of view. It notes the order of conditions, which has been violated, and further notes the consequences which were agreed to by the applicant back when the original order was issued. So I want to say that I think this is I think this is an excellent summary of many, many years of work and angst. And I appreciate the work it went into to put this together. And I think this is, with the amendment, which would take care of what Ian said, and maybe there's other commissioners who have other ideas for amendments as well. But I would think and would be willing to move at whatever point's appropriate that we adopt this order of conditions. I'm sorry, this enforcement order. So.
Thank you, Maureen. Any other comments, additions, questions from commissioners? Jeff?
So just to add it, because there was no formal enforcement, it was a violation of that order from 12/11/19. So I just added the note. Hopefully everyone can see it there. I just put an asterisk with the 12/11/19. And then I just put, in addition, on April 2nd, 2020, the commission found by unanimous vote that on March 27th, 2020, the applicant violated the existing cease and desist order that had been in place since 12/11/2019.
Thank you, Jeff. Again, any other thoughts, questions, additions from commissioners?
Just one, Madam Chair.
Yes, Linda?
Why is it necessary to do this today? Instead of waiting for Arcadis, or waiting to see if they'll put a new application in, or waiting for our joint meeting with the selectmen? Why is it necessary to do this today in particular?
So Linda, we've waited 2 months on this. So it's one of those things we need to make sure we're getting our paperwork in line and finishing up what we started. The Arcadis report, although it's informative, it doesn't speak to our regulations. So, you know, I understand the confusion that the two things are connected, but they are in fact not connected. So, you know.
I do know that, Madam Chair. I'm just wondering why we just don't pause for a second until we have conversations with other people, namely the select board, and wait for Arcadis to see if that's something that the Bluff wants to apply for, et cetera, et cetera. I'm just
Yeah, I mean,
concerned.
in my opinion, we waited over 1.5 years for the select board to not answer about enforcements on this project. You know, we reached out to them first, technically, in April 2020, and they didn't respond to us, and enforcements kept piling on. So that's, again, a big issue. So it kind of goes both ways, but I think it's important that with a project of this magnitude, it's kept in compliance, and willingly kept in compliance, because, you know, I realize there's a difference of opinion, but when we met in March to see the 2019 SAND report, the letter we received back didn't imply that they were willing to get the project back into compliance. It actually said they were willing to keep it covered at a minimum until they got their expanded project. So again, it's really important that we deal with these issues in a timely manner and not allow for potential harm to our resource areas. If this drags on, there's the potential for it not to be in compliance by the next storm season, causing potential further damage to Downdrift beaches. Because unfortunately, you stated earlier that there's been no harm, but we have had neighboring property owners claim that they've had damage to their property. So we have to take that into account and, again, act within our regulations. And that's what we're doing here.
Madam Chair, are you going to be taking responses to all the incorrect things you just stated, or do I have to wait till the end? Because frankly, I'm shocked at some of the conclusions that were just stated into the record. And I hope we get a chance to respond to them.
Stephen, you will have a chance to speak. I'm sorry if I was inaccurate in the way I've read some of the correspondence. But, you know, this project stands alone, and that's why we are looking at it right now. It's not tied to an expanded project. And some of the correspondence from Mr. Posner, made it seem like they weren't going to do anything if there wasn't an expanded project. I realize that legal counsel for SBPF has kind of said different to that. But that's kind of what his letter stated. So, that's the way I read it. And we've
Yeah,
mentioned.
I guess my point is that's 3 letters ago at this point. It's not current information, but it's being portrayed to the public in this meeting as if it was the last and final. So, but I'll wait my turn.
Okay. Seth?
Thank you, Madam Chair. I think it's important to remember that this enforcement order is related to a very specific issue related to improper placement of sand nourishment material. So I do listen and I hear what Commissioner Williams is saying. And I think that a discussion with the select board regarding long-term planning processes in the area between the Conservation Commission and the select board is certainly warranted. I think also reviewing the Arcadis report, which is a consulting firm providing an advisory report, is warranted as well, but it's not necessarily germane to the specific issue at hand. Our process here is to determine if the current project and the current applicant has met the order of conditions or not. And if they're in violation, which we found they were, to move forward with enforcement issues. I know that the applicant has, or not applicant, permit holder has, and the select board has discussed the possibility to amend this order to have a sand mitigation plan put into place. That's an alternative, or moving forward with the removal order is an alternative. But doing other processes like waiting for Arcadis or waiting for the select board is not really what the purpose of today's meeting is.
Thank you, Seth. Any other amendments, questions about the order for removal? Okay. So I think before we would go to issuing that out, we should at least briefly discuss our other options and what was put in front of us, including, the proposal that came after our June 30th meeting, I believe it was, from SBPF. Also looking at the proposals that came from, the Land Council with differing sand volumes, because, again, those are options on the table for us. So I don't know if any commissioners would like to share their thoughts on, again, those other options to try and get this back into compliance via SBPF sand proposal, or, some of the other sand mitigation proposals that have come before us.
All right, I'll raise my hand again somewhere. I think it's incumbent upon us to consider those options, that letter from July and the one that we received today. And I think it's incumbent upon us to have a public hearing, but they have to make the application for us to consider it. Is that correct?
No, this is like their plan to catch up. So this isn't amending their order. This is trying to rectify the enforcement. So it's a little bit different. Jeff?
Okay. So I think we should give them that chance, but I know you've given them multiple chances, but that's where I am.
Thank you.
If I may, Madam Chair, I'll just clarify the process, that just to make sure that everyone understands. So currently right now, from the 2019 and 2020 reports, the commission found that they're in deficit for what the permitted amount currently is. And I think that everyone has come to some agreement that there's a deficit. Linda, the easiest way to deal with it would be if you were going to play catch up and work on that, that would be done through the issuing of the enforcement order with specific instructions on how that catch-up was going to take place in the time frame to take place. So it would be ordered through there. If there needed to be an adjustment to the permitted nourishment volume, that would take the amending of the order of conditions. So that would be two separate processes to do those two things. I think that's the question that you were asking.
Through you, Madam Chair, how do they do that once this order to remove is enacted, is voted on, signed, and filed? How do they then bring it current? Wouldn't they have to apply for an entirely new application?
At that point, yes, they would.
Okay. Thank you.
Thank you, Linda. So I know, I guess I'll start. When I look at the SBPF proposal to catch back up on mitigation sand, I am concerned about the discrepancy between their proposal and what we saw from, I believe, the Land Council and maybe the Green Hills. You know, it's half, or, you know, right around half of what they suggest when you look at an actual year versus SBPF sand years. And I do find that to be a major concern of their proposal to catch up. And my understanding of their order of conditions is that a year isn't a sand year, but a calendar year. So my feeling is if they were to re-nourish this or try and get back into compliance, I would actually be looking at the higher volumes that were proposed versus what SBPF sent us after June 30th. I don't know if any other commissioners have thought on that at all or have any thing to say about that. Ian?
Thank you, Madam Chair. For the record, the amounts that were referred to, SPPF's consultant, Mr. Berman, arrived at the figure of 26,636 cubic yards. Mr. Ruthven, for the Land Council, arrived at the figure of 46,537 cubic yards. And Dr. Kriebel came to a figure of 47,405 cubic yards. So as you rightly said, there's a significant discrepancy. Thank you.
Thank you, Ian. Seth?
Thank you, Madam Chair. I believe Mr. Golding meant to say that SVPF's consultant was Mr. Dunk, but Mr. Berman is the third-party reviewer for the Conservation Commission. But I think that if we did move forward with amending this enforcement order to be a sand mitigation plan rather than a removal, any lick would need to be any plan would need to be updated to deal with that discrepancy. I read the order of conditions as it being a calendar year, not a sand year. And I think also since it's been over a month now, 6 weeks since the sand mitigation proposal was filed, there would need to be a adjustment to the amounts being listed as well. It would likely be a minor, but it's my understanding that sand isn't being placed. So there would need to be a minor adjustment to the amount that was added, because we're already, I guess, getting into a further deficit than we were in the middle of July.
Thank you, Seth. Ian?
Thank you, Madam Chair, and thank you, Seth, for correcting me. And it was pointed out that the difference between Mr. Berman's calculation and the two other was that he was apparently working with SBPF's definition of a sand year, which in 1 year contained 22 months. And that the 20,834 cubic yards required for the permit was for a 12-month year, not an SBPF year. So according to the permit amount, 22 months corresponded to 38,196 cubic yards. So just to clarify, to try and correct what I said. Thank you.
Thank you, Ian. Seth?
And just to further clarify what I said relating to the year requirement, the specific condition in the order of conditions that calls that out is order condition 32. It says 22 cubic yards per linear foot per year. And then it talks about the schedule, but it doesn't say sand year, it says per year.
Thank you. Any further discussion from commissioners on the sand mitigation proposals to catch this up and get it back into compliance? Maureen? Oh.
All right. I have a general comment. We see many applications during the course of a year, and many of them, the applicants comes back several times because we've made comments on what they've suggested, and sometimes they change it based on our comments, or they don't, or what have you, and we eventually get to a decision one way or the other, with maybe conditions added that bring it into compliance from our point of view that maybe the applicant hadn't put in to begin with, or sometimes it's just they withdraw it, and that's kind of how it goes. But we have a process that, as far as I'm aware, has worked very well for decades, and what's being proposed here is to, rather than follow our stated process, which I think is really important. I think applicants need to be able to know what the rules of the game are. And if we decide to put this, to accept what the SBPF appears to want us to accept, which is looking at a sand mitigation process, yet they have never, as you said earlier, Madam Chair, they have never filed a simple amendment, seeking an amendment to the order of conditions. This isn't hard, it's not expensive, it's not backbreaking, but they have chosen not to follow the stated rules for what happens if you don't like what happened, if you think the sand is too much or too little, and in this case, and I don't think that it makes sense to upend our very useful regulatory scheme because of decisions made by a particular applicant based upon, I'm not quite sure what, but based upon beliefs, I guess, that somehow the order of conditions was not something that actually had to be attended to. So I just think it's important to put that out there. This is I used the word unprecedented at an earlier meeting, which caused some bother, but I do believe it's very appropriate to use it here. This is unprecedented in terms of putting together a new rule book for this particular applicant. Thanks.
Thank you, Maureen. Any other thoughts about the sand mitigation proposals to catch this project up and keep it into compliance, or get it into compliance, excuse me? Looks like no. And then we also, have the potential, it would obviously take a vote to reconsider. Jeff should have sent out a draft letter to everybody this afternoon that would, allow us to try and meet with the select board. I don't know if any commissioners have comments or questions about that, but now would be a good time to discuss that before we kind of open up to the public. Jeff?
Real quickly, I'm happy to screen share that letter too. I know it didn't get posted to the website yet because it just got sent out today. I mean, after like 3:20 p.m. We're getting ready for the meeting. So I'm happy to put it up, but it will be posted and available for everyone to see, even if you guys don't discuss it since it was sent out.
Sure, Jeff, it might be a good idea to screen share for people because I'm sure commissioners didn't have a lot of time to look at it either.
All right, we'll put that back. And then everyone
think the
can see it.
letter is
Again, I
appropriate,
apologize
Madam
to everyone, but it literally happened today.
Yeah.
At like post 3 p.m. So.
I'm glad to see the letter, Madam Chairman. So I'm in support of the letter.
Thank you, Linda. I think, Jeff, one thing that we maybe discussed that isn't in here was a deadline to set this meeting so that this didn't kind of delay any further than it needed to.
Sure. Well, I think if this is something that you guys are interested in and want to take action, I think if you guys decide to issue out this letter, I think setting a deadline as part of that or setting a scheduling deadline for that can happen then. And then we can simply add a sentence to the end that says, we're hoping to have this meeting on or prior to X date, and then go from there. Because I know there's other scheduling concerns in there, and obviously a public meeting to get scheduled has a little bit of to do. So we obviously would want at least a couple of weeks to get that together, just to make sure that everyone gets notice and is properly noticed. But I think as long as you guys set that as any part of motion to issue that letter, I think that would be easily done.
Okay, thank you, Jeff. Seth?
Thank you, Madam Chair. I read the letter and I think better communication between Conservation and Commission and the Select Board is warranted, but I'm not sure what the purpose specifically that's being requested by this letter is. Is it just to request a meeting? What's going to be talked about at that meeting? I know it says actions and remedies to ensure future or ongoing compliance. Is that related to just this order of conditions, SE 48, 28, 24 only, or is it related to the area as a whole? So, I mean, I think that, you know, the town is a party in this matter because they're the property owner, and the select board is the body that is responsible for managing the town's interests. So I think meeting with them to talk about ongoing compliance is good, but I'm not exactly sure what the point of the meeting is. So maybe you could clarify.
Jeff?
Sorry, I'm screen sharing. I have to wait for my little menu to drop down to unmute. I think the intent, Seth, was to go through it and kind of, you know, from comments from the last meetings and a couple other commissioners. I think the intent first and foremost is to get the structure that's on the ground and permitted by SE 48, 28, 24 back on either a track to compliance or settling on, you know, terms of removal, but obviously to engage the property owner in this case to how best to move forward with the existing situation. I mean, I think we all understand that there's a greater planning effort at work for the whole area, but I think that work may not directly address the current issue at hand completely and in a manner that's quick enough to respond to that. Because I think, some of the options for that report that were being discussed, and, if anyone's watched the discussions that have gone on with the stakeholder groups in Arcadis, obviously there'd be permitting for a lot of those things. So I think, to remedy the current enforcement, I think the intent of this meeting would be to deal with the structure as it currently sits and to kind of, start the discussion about longer term, but knowing that longer term discussion may take longer than what is really important for getting a structure either on the way out or back into compliance or on the path to compliance.
Seth?
Thank you, Madam Chair, and thank you, Jeff. So that makes sense, but to further clarify, sending this letter and requesting that meeting, by doing that, we would choose to delay the current process that's at hand today. Is that clear? Is that correct? And also, the context of that meeting, it would be strictly based on the Conservation Commission's regulations, the Wetland Protection Act and the local bylaw, or would it consider the select board's charge as well? Because I know they have their own interests and protections, or I guess their own interests that they need to protect that aren't necessarily germane to our process. So would that meeting talk about that, or would it really be just focused on the ways to get this project into compliance?
So Seth, my understanding of this meeting would be looking at the project as a whole and all aspects of compliance. So not only Concom compliance, which we know is out of compliance, but also looking at the select board, not memorandum, licensing agreement, and looking at all aspects of non-compliance for this project. And my other understanding is that, yes, that would delay us issuing the enforcement at this point. But I don't know if Jeff has any other kind of thought on that.
Sure. So through you, Madam Chair. So I think, again, the intent, yes, was to address, and the letter specifically talks about, reviewing that license too, and, kind of coming together to make sure that there aren't other outstanding issues, and just to make sure that, we're not setting up on a course of action through the Conservation Commission and the Select Board together and not taking into consideration either other outstanding issues, or we're not ordering work to be done that isn't necessarily in compliance with, the license agreement or other standing in agreements, and putting, the permit holder in this case in a little bit of a quandary or an issue with another one of their issued permits, that those are working together to accomplish those goals and not opposed.
Seth, and then Maureen.
Thank you, Madam Chair. I'll let other people speak soon, but given that context, I think if the discussion was focused on the non-compliance issues related to our regulations and to the license or whatever other agreements might be in place, I would be in support of doing this, but I don't want it to divulge into the other topics that exist, like maintaining public infrastructure or access. That's the select board's charge. I know that they're responsible for doing that, and I don't envy them for doing that, but that's not really germane to the conversation here. It's as long as the conversation is related to ongoing compliance of this project, I support doing that.
Thank you, Seth. Maureen?
Yes, thank you, Madam Chair. So having not had, very much time to look at this letter, I guess my concerns, I share some of the concerns that Seth mentioned. And but first I want to say we are in this very awkward position with our select board where they have denied funding for us to have our own legal counsel on these issues because of the potential or perhaps actual conflicts of interest between our enforcement of the wetlands bylaw, as well as the issues that the town has wanted to have a kind of a three-way cooperation deal between the Concom and themselves and the applicant. And so, reading this letter, I was just thinking, I'm not sure. Frankly, I would want us to have independent outside counsel look at this. I'm very concerned about us putting ourselves in the position of, or helping put ourselves in the position where we are, where Arcadis is somehow still relevant to this mess, where, to what we are specifically dealing with. It literally and figuratively muddies the waters if we start thinking about the extension request, which is currently with the Superior Court for a decision within, I hope, a few weeks. That's certainly material to the realities on the ground here, so to speak. But SBPF has made it clear, and Mr. Posner has made it clear, both orally and in writing, that he links those two together. And if they can't have what they want for the existing array, then and they don't get what they want for the extension, then they're going to abandon the existing array. And which is, it's a tactic which I find abhorrent. I find it very difficult to to consider other things other than what is before us. Now, the one area that I think is important for us to think about is the town as the property owner. I mean, that's a very valid concern. And that is they can, as property owner, they would be kind of one of the parties, working with us on this. But I just don't feel that that is how this has been done. And the fact that we were absolutely excluded from the executive session where the select board voted to voted to ask us to reconsider, and as well as their session where they decided that paying our legal fees were not appropriate somehow. I want to work with them, but I also want to make it clear that we have the wetlands bylaw is, as Seth, I think you were basically saying this, that's our game. That's what we need to worry about. And I'm willing to talk to the town as property owner, but I do not feel that, saying that whatever Arcadis might, I know that's not in here, but that this is, in any event, I guess I would just go back and say, I'm not comfortable with this letter without having independent counsel look at it. And that would mean the select board would have to be willing to pay for it. So they would have to take some action there and then we can go on. So that's how I look at this. So, thanks.
Thank you, Maureen. Any other thoughts, comments from commissioners about issuing a letter to the select board?
I've got my hand up again,
Okay, Linda?
the little yellow hand.
I'm not a host, so I unfortunately can't see those hands.
First off, I think this goes forward today. I think it's going to result in more litigation at the Superior Court level as well as DEP. And I think we've had enough of that. As far as what Maureen said, the town buy-in is happening now. It took them quite a while because when I was on the planning board, we were talking about easements, if something happens to Baxter Road, et cetera, et cetera. Taken the town a long time to buy into this whole process, and I don't think we should turn them down for having a conversation. Nor Seth's parameters. I don't think we have the right to tell the select board what they can and cannot discuss with us. I think it's a wide-ranging discussion between both sides to make sure both sides understand what the positions are and what the jurisdictional issues are between both boards. So I'm not willing to put any restrictions on what they want to say to us. I think that's bad. It was my understanding that enforcing the local and state laws regarding wetlands, one of the biggest tenets is whether it's detrimental to the natural resource, whether it's got a negative impact, loss of habitat, light scatter, et cetera, et cetera. I personally am failing to understand how leaving them in place while we work through all the rest of this stuff and then make another application, seeing what Superior Court results in, is detrimental to the resource at the moment. I just don't see it, but that's me.
Thank you, Linda. Again, we have received information at previous meetings that there has been damages to Downdrift beaches, and especially the sand nourishment component. It is very important that they are in compliance with that because there can be unseen consequences for years, actually. You might not be able to recognize them and tie them directly to the project right away. So, these sand volumes were come to over months and months of hearings. And again, the DEP had the same sand volumes in their superseding order. So it's a very, very important component of the project, and it's not something that can be left out of compliance to kind of wait. But I appreciate your comment. Mark?
Thank you, Madam Chair. I have a feeling most of us know what the selectmen are going to try and argue with us about, and that is they're worried about Baxter Road. And they've already made that very clear in the newspaper several times. I think we'd be remiss if we didn't give a chance to hear them out. But I think we should do it promptly. We shouldn't delay any more than we have to. They've made it very clear they want to meet with us, and I'm surprised that none are on the call today. And they've been on the call in the past, but never said anything, which is, again, I thought that was a little strange. They didn't speak up when they had the opportunity to. But I think we should give them the opportunity to have a joint meeting and see what they have to say, and have that ASAP in my book. Thank you.
Thank you, Mark. Ian, go ahead.
Well, I think it's a very awkward situation. From the way I read it, and Mark refers to the paper, I had a certain level of astonishment at apparently the ignorance of some of the members of the select board. If they had read our 9-page memo, dated, let me see. Well, it's not a memo, and it's to the Mass DEP on February the 4th, 2020. I don't see how they could possibly have made some of the comments that, if the newspaper is accurate, that they have. And I don't see they've made it absolutely clear by asking us to reconsider and denying us independent counsel that they want us to work back our wetland regulations and ignore them. So, I'm certainly conflicted because I can't, because both, I mean, Maureen, Seth, and Mark have all made valid points. And ultimately, I think that if we meet with the select board, they're going to say exactly what they said before, except the one critical difference is that they are not supporting us as a town commission, which I feel they have an absolute duty to. Otherwise, what's the point of having a commission in the first place? So I'm perfectly happy to speak to them after the enforcement issue, because then maybe going forward, there can be a compromise. Thank you.
Thank you, Ian. You know, I have to say I am conflicted. I would like to have an open discussion with the select board, but at the same time, I have made myself available during their executive sessions on this topic and was not allowed attendance when these recent matters came up. I also find the fact that we were not allowed independent counsel so that we as a commission could navigate this to be very unfortunate. I feel like they've kind of tried to tie our hands in a way, and then, you know, we look poor when we don't then meet with them kind of on the flip side. And again, I think that that's a very unfortunate component of this. I know, speaking to what Ian just mentioned, and maybe Jeff can speak to this, I believe it is possible to issue out the enforcement with the potential of rescinding it upon a select board meeting if something came out of it. Jeff, can you speak to that aspect of this?
So I do think that's an option. I think the one thing that's important to note with that, though, is once it's issued, it starts a clock on an appeals process and superior court process. So enforcement actions, again, just as to remind everybody, they get appealed not to Mass DEP and to Superior Court as a normal order of conditions under both the State Act and the bylaw go. Enforcement actions are solely appealable to Superior Court. They don't really have that, excuse me, that DEP step. So that would be the one, you know, concern I have about doing, you know, kind of both at the same time is obviously, you know, with appeal rights and getting started and into Superior Court. If you issue and then are going to schedule a meeting behind that, is that window can get very small for either, you know, either the town itself or, you know, the permit holder in this case. But that doesn't necessarily mean you can't do it.
Thank you, Jeff, for explaining that. Seth?
I'd be opposed to that strategy of issuing an enforcement order with the idea of rescinding later. I think if we're abundantly clear that we have the information needed to issue the order, we should issue the order. If we think we need to collect more information from meeting with the select board, then we should wait and meet with them and then discuss issuing an order at that point. But I think it's a very bad position to be in to issue something that you're not abundantly clear on what the intentions of it are. So I wouldn't want to do that.
I agree with Seth.
Thank you, Seth. I do agree with you, but you know, wanted to kind of throw that potential option out there. Maureen, I saw your hand up.
Yes, thanks, Ashley. I guess as this gets more complicated as we talk and, you know, what might we do or not do, I want to reiterate, I think it's really important for us to have our own counsel so that we can have somebody who would advise us, well, if this is done, then what can happen here? And and what are the downsides to this, the appeal periods, all these things which would be, in my view, proper for us to take to town council, but that is, we have made our own decision that we don't believe town council that they have a conflict of interest because of the actions of the select board. So I would be willing to have a meeting with the select board if we have engaged counsel and we've had an opportunity to talk with them. And I'd be willing, we could make that happen as quickly as possible. But I feel like we're going in kind of naked without having that level of expertise behind us, because clearly the other parties involved, the Sconset Beach people and the town, have, a lot of expertise available to them that we do not. And I am feeling that this should be a fair process, and I don't think it's fair unless we have our own counsel.
Thank you, Maureen.
I have another comment then. Madam
Go
Chair.
ahead.
I'm kind of taken aback by Maureen's comments. I think we are all work for the town. I think we all have a common goal, the betterment of the Nantucket community and the environment. I don't see us as adversaries. I don't see us as hostile towards each other, and I don't see us as having divergent goals and objectives with respect to our own boards. So I think we're all on the same side here. It's how we're approaching the bigger picture within our own realms of jurisdiction, I think, is what is at cross purposes here. They're not considering necessarily our jurisdictional issues, and we are not necessarily sympathetic to their jurisdictional issues. And I think a joint meeting is where we can sort of hash that out and everybody can figure out what domains we have to stay in, what's our lane and what is possible. So I don't see the need for a separate council, and I didn't before, and I voted against it. So I am still having a problem with thinking that we are at cross purposes and we're hostile and we've got battle lines drawn. I just don't see that necessary. I think we need to have an open line of communication, as Ashley said earlier, and I think that's going to be very productive.
Thank you, Linda. I think, the Concom, we've been very clear we know what our lane is. We're working with our bylaw, the state act, and the permit in front of us. And we are well within, grounds to do what we're doing. I think, unfortunately, I don't think we're against the select board. That's not the way I see this, but I do worry that they aren't recognizing the importance of a regulatory board that's done a lot of work here. And they've maybe deviated from their lane by trying to manipulate our process. And that is concerning because we do need to uphold the wetlands bylaw here in the state act, regardless of select board pressure, political pressure, community pressure. We have a clear bylaw to uphold. And if we allow ourselves to be pressured by different entities, then we're not doing our job correctly. And that's when resource areas will really suffer. So that is a big concern for me here.
I don't think they're trying to tell us what to do. I think they're trying to understand what we can and can't do, and we need to understand what they can and can't do.
Seth had his hand up, and I'll recognize you next if you'd like to speak again. So Seth, go ahead.
Thank you, Madam Chair. You said most of this already, but the processes are independent. Conservation Commission has their jurisdiction and their regulations to uphold. The Select Board has their charge to uphold. Generally, these processes are not at odds, but there's times when it becomes difficult to maintain the interests of both boards when you're stalled like this. And I think we need to move forward independently with our process. And what I was saying before is things like long-term planning and public infrastructure and and access are certainly important issues on Nantucket, and it's something that we all need to consider. But it's not our job to steward those interests. That's the select board's job. And they can do that job independent of whatever we do. They need to do that job independent of whatever we do. So even if this removal order goes through, they're not just going to stop their job. They're not going to say, okay, we're abandoning all the interests in Baxter Road. They're going to be creative and think about other ways to steward those interests. But it's not our job to tell them how to do that. It's our job maybe to listen to what they have to say. But ultimately, our goal is to ensure that projects are in compliance with the orders of conditions and are maintaining the standards of the Wetland Protection Act and the local bylaw.
Thank you, Seth. Any kind of final commissioners' comments before I allow members of the public who are on to speak? Okay, it looks like no. So Jeff, you'll probably have to help me navigate public comment because I can't see virtual hands for people who raise their hands virtually. But at this point, I will open it up to public comment. I'd like to remind everybody to please state your name. If you have some relationship to the project or you're a Baxter Road property owner, please state kind of your affiliation there and make sure to be brief and not repetitive if possible. Jeff?
So real quickly, Stephen Cohen had his hand up first, and then Dennis Murphy had his hand up second.
Okay, perfect. So Stephen, we'll go to you.
Madam Chair and members of the commission, I just want to thank you because I know that you're volunteers and you're trying to do the right thing, and this is complicated and difficult. And even though it's contentious, and even though I take a tone sometimes, I just wanted to start by thanking you. But I also think essentially that you're going down a path that you shouldn't, and that you're making some mistakes that you should be pulling back from. I took a look at the enforcement order, and I'd like to read it a little differently. You know, it notes the violations here and tries to make a suggestion that there's an aggregate amount of violations here that are problematic. When the reality is that this project was initially anticipated as having essentially a test period where we would come back and review and make improvements to the process. And some of these violations are really just things that were discovered as we were going, that were things that needed areas of improvement. And I would say that some of those violations and then the changes made based on them are just the success of the process that we had put in place. That's not to excuse any violations, but I don't think that you know, some of them should be characterized so maliciously. Secondly, while SBPF is very clear that some of this sand is deficient, I also want to note that, you know, SBPF came out with this information publicly and it wasn't trying to hide it. And part of the delay in dealing with it was that we had COVID and then we had a stop work order and there were a bunch of other things. And, you know, I think Mr. Posner has said in a prior hearing that he was less inclined to fix it until we knew the situation globally. And I, as counsel to SBPF, quickly officially wrote in and said, you know, that was not the official position and that SBPF is willing and able to remedy this situation. And SBPF has submitted a plan to do that. And in fact, the Nantucket Land Council has also submitted a plan suggesting a remedy, and that the timeline for doing those remedies and the process for doing those remedies were remarkably similar. There's some question about the volume of sand, but I don't think that we're really that far off on what the solution is here. It's really just a matter of finding a way to implement it. But what I was really disappointed is that this commission did not respond to and has never had a hearing on reviewing those things. We talked about them briefly today, but the enforcement order was requested to be from Jeff before we've ever had any discussion on compliance. It's very unusual for there to be a decision being made without reviewing the file and the information submitted to the file, which is what happened here. When those compliance plans were not, when there was no hearing on those compliance plans that were submitted, either the one by my client or the one by the independent third party. So that was a very unusual thing to do. And I think the commission would be in a much better position if it went back and issued considered issuing a compliance order instead of a termination order. The other thing is that the commission is taking a very unusual approach, which is that this approach seems to be punitive, as if you're frustrated with the applicant and therefore you want to take the most possible termination approach possible instead of actually fixing the problem. Nothing about the suggested term about removing the geotubes actually addresses the problem. In fact, removing the geotubes would cause a massive problem. It would prevent the bluff's ability to prevent storm damage. It would not protect any of the homes and public infrastructure that has rights under the state and local bylaw. And it would be its own resource disaster, and you would have a massive erosion. You'd also have to rip out the geotubes that are below grade. You know, it is just poorly thought out in terms of process with a 60-day rip it out order. And frankly, again, I think it's punitive, not thoughtful. And I don't mean that Jeff wasn't thoughtful in drafting it. I mean that what Jeff was requested to draft is not responsive. This commission's own order says that if the applicant is not in compliance with the order, that the commission should bring the applicant should appear before the commission and the commission should take action to bring it into compliance. And there's been no order to come into compliance. And the idea that a termination order would be issued before a compliance order is very shocking to me. There should be a compliance order, and if the compliance order is not complied with, then perhaps a termination order. But to skip to termination is highly, highly unusual. The other thing is that there's no harm done by the lack of compliance here, in the sense that the sand that has that is deficient is template sand that is just above the use line. So in other words, there's never been a point in time where the geotubes were not covered or where nourishment sand was not taken out into the ocean due to this deficiency. It's like suggesting that, you know, a car that only had half a tank of gas couldn't drive. Well, you know, the fact that the tank wasn't full didn't matter. The half a tank, you can still drive. And that's the thing here, that the template always had enough sand to push over to recover the geotubes. There was never a time where it wasn't, you know, covered in compliance, and there was never a time where there was not sufficiently available sand. It's really just about the storage sand that we use to push over. So the suggestion that a deficiency there could have led to some harm is almost nonsensical. It doesn't add up. Now, if someone wants to suggest that the project itself is causing harm, that's a different issue. But you cannot argue that the lack of compliance with the sand requirement is causing a problem, because there's never been a time where the sand that needed to be available was not available. So the commission really should consider whether or not there's any actual harm here, and whether or not there are any actual ways to resolve this without termination, and whether or not termination is going to lead to other bigger problems. And I think that the answer to all of those is, you know, there's been no harm. There is other ways to fix this, and implementing this order is a disaster. And I mean that environmentally, I mean that from a public policy point of view, and I mean that from a good government point of view. Government shouldn't be punitive. And I appreciate your time, and I'll end my remarks there. Thank you.
Thank you, Stephen. So Dennis Murphy will go to you, and then David Bailey, I see you will go to you next.
Hi, thank you, Madam Chair, and members of the commission. Dennis Murphy from Hill Law on behalf of the Green Hills. I just wanted to make a few quick points. First, a factual clarification. The letter that Kriebel and Ruthven submitted in June calculated the cumulative sand deficit as of the end of 2020, it was 47,000. As of today, it's more like 62.5. So if no sand is going over the bluff, the deficit continues to grow, and it is approaching now a 3-year deficit. First point. Second point, the permit holder is SBPF, not the town of Nantucket. SBPF has promised and suggested that if they don't get what they want, they will simply turn over the project to the town. That may happen, and if it does, then a joint meeting with the select board may be warranted. But right now, that's not the situation you're in. You're dealing with the applicant and the permit holder that you have in front of you. And the rest of it is politics, quite frankly. And this is a regulatory proceeding, and I suggest that we leave the politics out of it. The worst that can happen to the 5 of you is that you might not be reappointed. They are your appointing authority, and I respect that you might be concerned about that. Nevertheless, I would commend you, as any board that I represent or appear in front of. You can't be wrong if you vote your conscience and you act in the best interest of the town. My last point is that what we're here to do today is to memorialize votes and actions this board has already taken. What Attorney Cohen has suggested to me is too little, too late. That is, we had a public hearing. It ended when you voted on June 30th. I was there. You had a process before that on May 17th, in which you also took votes and testimony. And I think this can't go on ad nauseum, because from my client's point of view, there is harm. And it's not just to their property. I think there's harm to their natural resource areas that the commission is charged with protecting. And the longer this goes on, the more harm that accumulates. The final point I would just make, and I know I said 3, but let me add a coda. The permit expires in less than 90 days. And ask yourself, if you wouldn't vote to renew it, then why would you vote to have any further conversation about it? Thank you very much, and appreciate the opportunity.
Thank you, Mr. Murphy. David Bailey?
Yes, can you hear me?
Yes, we can hear you.
Madam Chair and Commissioners, thank you very much for giving me the opportunity to speak this afternoon. I am both a Sconset Civic Association board member as well as a Baxter Road homeowner. My wife Dorothy and I have been coming to Sconset for over 35 years and purchased our home at 100 Baxter Road in 1995, obviously squarely in between the 87 to 105 addresses. In conjunction with developing the Sconset area plan, the SCA sent out a questionnaire to our membership early this year. 2 questions related to Baxter Road and bluff erosion, which I thought the commission might be interested in. First, and I quote, "Do you think the town should support actions to try to prevent further erosion of the bluff?" 72%, 379 people answered yes. 18% said no, and 10% had no opinion. Second, regarding cultural and natural resources, the survey asked, what places do you frequent or like to visit on a regular basis? The number 1 answer was Sankaty Head Lighthouse. Number 3 was the Bluff Walk. And you should know that 80% of the respondents are homeowners here. Our membership supports reasonable efforts to preserve the bluff and the beautiful walk up Baxter Road to the lighthouse. Sitting on our porch, I can tell you that on a nice day, there are hundreds of people that pass in front of our house, walking, jogging, or biking up to Sankaty Head. It is the SCA board's view, and my hope too as a homeowner, that we wait for the results of the Arcata study and consider the alternatives before taking action on the geotubes that currently are protecting the bluff and Baxter Road. Thank you.
Thank you, Mr. Bailey. Margaret, I'm not sure if your last name is McQuaid. It's cut off, but I did see your hand up as well. You're muted.
Can you hear me?
Yes, we can hear you now.
Margaret McQuaid, 97 Baxter Road. I will start by commending any and all of you who contribute to governance on this island. It's not easy and it's complicated, and this is a very good example of how complicated it is. I have to admit my vantage point is less complicated. I love where I am. I've loved it for a long time. I've already had to move half of my house. And so my understanding of consequences is very real and very painful. I think that the Sconset Beach Preservation geotubes have allowed me to survive, to still be there. Without them, I will not. So I look to you all to make a very fair decision, because real people are affected. It's not just a theoretical project. It's real property, it's real houses, it's real people, it really is Baxter Road. And this is the most successful thing that has been done. And it has been done with tremendous care to the science of it and the implications of it. And as someone just mentioned, taking out these geotubes will have, believe me, I will be very hurt, but so will many, many other people, and so will the island. I feel that any rush, and I don't care how long you've been doing it, if there's no willingness to talk, either to SBPF or to the select committee, then that's inappropriate in my view. I look at the Hurricane Ida and I hear all these people, I hear their tales, and they're terrible what they have lost from this devastation. You propose to do something that would be man-made destruction of something that is working, that something for 8 years has worked. Is it perfect? No, but most projects are not. But I think it deserves every consideration, and that the effort should be made to see some sort of good conclusion, not an effort to be made for who's ahead and who's behind. And I've heard it, I will not mention names in some of the comments made today. I don't see it as a contest among us. I would like to see it as a contest as to who and how we can reach the best conclusion for this island. And if we reach a good conclusion for Sconset, for the Bluff, with a recognition of the value of these geotubes, I think it can have ancillary impact on the rest of the island and be a benefit for them. So when people say, look to your conscience, I say, yes, look to your conscience. Look for the real people that are being affected. And I have worked on this project all these years. I believe in it, and I believe in sharing. And one of my great, great disappointments is the lack of support from the rest of the island for what has privately been done on this end of the island in Sconset. So I urge you to give whatever time it takes, whatever consideration of views you think is necessary. Do not look to destruction as a solution. Thank you.
Thank you, Ms. McQuaid. I think we do all recognize that there are real property owners involved here, and that it's a very difficult, situation that we're in. But I appreciate your comment. And again, we understand that there are real people involved here. And I think we've understood that.
I hope so, because in some of the comments that is clearly not apparent.
Right. So sometimes, unfortunately, not everybody will be happy with an opinion or the direction of the commission, but we realize that there are people involved. Seth?
Yeah, if I may, Madam Chair, I have a technical question for Jeff related to something that I forget who said it was, but related to who the permit holder is here. It's my understanding through our regulations that if the applicant and the property owner are two different parties, then it was Mr. Murphy who said this, and an order of conditions is received, both those parties are the permit holder. Is that correct or no?
So that's, well, I'll try to make this as simple an answer. So when you apply for a notice of intent, right, you sign on as the applicant, and you also require the property owner signature for where the work is going to be taking place, in one way or another. In this case, with the property owner as the town, that also involves a licensing agreement. If it was two private property owners, you would need sign off from the property owner that's there. And then once that permit is issued, a copy is then provided to the applicant, and a copy is then required to be provided to the property owner as well. And then that order of conditions is then also recorded against the title of property for any of the property owners involved. So everyone's kind of in it together to some degree on an order of conditions that issued. Most of the time, the applicant and property owners are the same party. I'd say that's 75 to 80% of what we see. In this case, you have a singular applicant with the Wisconsin Beach Preservation Fund. And then not only is the town a property owner involved, but there are a number of private property owners that are also involved with the project, because the geotube kind of splits the property line going up the bank a little bit. So there were a number that were required to sign on, and then it's put on the title against everyone's certificate of title or their deed. Hopefully that answers your question.
Seth?
Yeah, I think it does. I mean, I think to me, if the order of conditions is being recorded against the deed, then that would imply that they're a party to the permit. So I think that all those people involved are parties to the permit.
Thank you, Seth. David Golden?
Thank you, Madam Chair. Thank you for just a couple of moments to speak, and thank you all for your service. I'm familiar with some of you. I had the opportunity to hear several months ago at a select board meeting, as I was an applicant for the commission in which you all serve. I lost that vote. I demanded a recount, and the recount confirmed that I had lost again. So I thank you for your service. I've been a summer resident in Nantucket for about 35 years. And a Baxter Road homeowner for about 20 years. I'm at number 70, so outside of the subject of the permit and on the western side of the road. And like Mr. Bailey, I get to witness hundreds of people walk by my front yard every day as they stroll up to the lighthouse and stroll back down to the village. And indirectly, I've managed to witness the saga of the geotube project going back to its beginnings. And back in 2013, it seemed like a rather thoughtful experiment. Let's see if there was a solution to a significant erosion problem. Let's see if it technically worked. Let's not charge let's see to it that the taxpayers didn't have to pay for this. And my recollection of the initial enabling permit gave them sort of 5 years, at which point it would be determined whether or not the experiment worked and whether it would be appropriate to extend it. Well, 5 years became 6 years, 6 years became 7, 7 became 8, and here we are. I think it's important to remember that the geotube system works if you view its intended purpose is to stop the erosion and the threat to Baxter Road. There's been no adverse effect that's been a finding of fact to other property owners at this stage. And the erosion for the limited number of feet that it covers has been stopped. And when I was considering an application to join this commission, I was trying to understand what is the constituency, who is supposed to be served, and what is the mandate of the commission in which you all serve today. And I went back and I read Title 7, Chapter 40, Section 8C, and the leading sentence is the mandate of this commission is the promotion and the development of the natural resources and for the protection of the resources of the town. That's right in the enabling legislation back in 1963. And I noted when Commissioner Golding commented earlier in this proceeding that the town won't support the commission. And I'm sort of wondering, what does that tell us? Who are you trying to protect, and who do you think ought to be protected by the enabling legislation? So we have a solution that hasn't cost anybody anything. I can't speak to the technical non-compliance issues, obviously the different findings of fact, but certainly rationality would suggest when it appears that the select board is looking for holistic solutions to protect not only Baxter Road and Sconset, but all other elements of the island that are facing the threats from rising sea levels, that we all lock arms and try and figure this out together. So again, thank you very much for the time and the opportunity to speak to you today.
Thank you, Mr. Golden. Other public comment? Meredith, I can't read your last name, sorry.
Sure. Thank you so much, commissioners and chairwoman. My name is Meredith Moldenhauer. It's a long last name. I am with my husband and my 2 elementary school children and our dog, proud Nantucket homeowners at 71 Baxter. Having just purchased our home less than 2 years ago, I appreciate that obviously we are new homeowners and have a lot less time potentially than obviously the Sconset years that have been mentioned by many on this call so far, and the years that many of the COMCOM commissioners have served. But I hope that my brief remarks may offer a fresh perspective from a family that loves Nantucket. I have not obviously been embroiled in a lot of the discussions and debate about the geotubes. And I appreciate that obviously the geotube debate and that there's been decades of discussion about preserving the bluff that have also been complicated by state and town litigation, permitting, regulatory compliance. But to kind of step away and kind of not discuss those issues, but rather kind of step away from the kind of acrimonies back and forth and the nuances of compliance, but answer the question that my 2 young elementary school kids asked me this summer about the bluff. I had to was forced to elevate my thinking about the issue. And I think that, I'm hoping that maybe looking at it from a higher perspective, different perspective this afternoon may help all of you in your challenging decision that I know you have to make and continue to make on many other matters. But hopefully we can agree that we're all committed to working together to preserve the island, and that is part of your bylaws, and that we need to work together as a Nantucket community to maintain and hopefully find a way for the geotube project to continue to be in compliance with the CONCOM bylaws. I would hope that we could agree that we are in a situation in which our world's climate is rapidly changing, having some of the most dramatic and costly impacts on coastal communities. Storms are increasing both in frequency and intensity, which is frightening, I think, for everyone on Nantucket. And listening to the news and looking at both our federal and state leaders across the U.S., many of them now recognize climate threats and are taking decisive action in searching for solutions to preserve coastal infrastructure. Local communities have a unique challenge of finding an effective solution, like you needing to find a solution that complies with your bylaws, but also protects the island. I feel that we are lucky that there is a solution already in place here in Sconset. Nantucket is fortunate that in Sconset you have hundreds of pedestrians who traverse Baxter Road, as you've heard from different people that talked today, from the market to the lighthouse, and that the geotubes are put in place there through your order and through that permit that allow that to occur. The geotubes have been protecting Baxter Road from being potentially shut down for the last 8 years. And we need to come to some sort of, solution to hope to maintain that. I appreciate that you guys have a difficult job, and perhaps the issues at play are, nuanced and more complicated, but from my vantage point, it appears to be potentially unnecessarily complex. I think that there needs to be kind of compliance, but discussion and working together is within your authority. And, removal does not seem to me to be the answer. It simply just creates new problems without any solutions. You have the authority, and it seemed like tonight you guys were discussing alternative options. You have a collective and a collaborative process where hopefully homeowners, individuals from the town can work together. And I would hope that potentially kind of after waiting, it sounds like from what I was hearing today, a year and a half from the prior order amid COVID, that, rather than taking kind of absolute action, that might seem like the wrong decision, but rather you have the authority to kind of take your time, maybe have a hearing, but to find the correct solution rather than just voting to remove. And I thank you for your time tonight. Thank you.
Thank you, Mrs. Moldenhauer. Any other public comment? And I do just want to, remind everybody to try not to be repetitive and focus on the wetland issues in front of us. RJ?
Thank you, Chair Arsman. RJ Turcott for the Nantucket Land Council. You, as a commission, have an incredibly narrow purview for Chapter 136, Nantucket Wetlands Bylaw. You have the information you need from experts, well renowned and respected in their fields, that this project is failing. And you need to issue the order. To do anything else would be to invite chaos. The Land Council provided a nourishment plan within the time frame of when it was asked. SPPF only provided theirs after it was voted that the project needed to be ended. So to allow an applicant or a permit holder to come back after a board, a town board, committee, commission has acted and walk everything back is going to set a bad precedent for not just the Conservation Commission, but every other board and committee. It's problematic, and this order just needs to be issued. The project is failing, and that's it. That's the only thing you guys are here to do. Thank you for your service.
Thank you, RJ.
I'm raising my hand.
Linda?
I take exception to the word failing. I don't think anybody has said in this 2 hours, I guess we're almost 2 hours we've been on here, that this project has failed. I think there are compliance issues that they're trying to work out with us. We probably should give them a chance. I've said that 10 times today if I've said it once, but I don't think anybody has said that this project has failed. So I take exception to that comment.
Thank you, Linda. It has clearly met failure criteria, so I think that's where that is coming from. Because again, failure criteria are outlined in their permit.
Right.
And I do believe it actually states this project will be deemed a failure if you meet these criteria. So it is.
Is it a compliance criteria, Madam Chairman, as opposed to the actual failure to do its job? Are those two different things?
So, I mean, I have to get the order in front of me. Unfortunately, I'm toggling all the faces.
Yeah.
I mean, they are out of compliance. They have also met failure criteria, which in their permit, I believe, says this project will be considered a failure if they meet the failure criteria. But again, I'm not using the right language because I'm trying to navigate Zoom and don't have multiple screens to look at this time. But,
Check it out.
yeah. Seth, I saw your hand up.
Yeah, I mean, we're just debating grammar at this point. It's been recorded not only in the meeting today, but at the vote we took that the project had met failure criteria. So to say you take exception to the fact that it is failing is a grammatical issue. If you take exception to what the consequence of the GO2 failure is doing, that's a separate issue, but it has been recorded several times meeting failure criteria. And I do have the order in front of me, and it does say that if these criteria are met, it will be considered a project failure.
Thank you, Seth, for pulling that up. I need bigger than a MacBook Air to run these meetings. All right, any other public comment? I want to make sure that the members of the public who are on have a chance to speak. And Jeff, if you see hands that I don't see, please let me know.
Yeah, I'm looking, I don't see any other of the nice yellow hands popping up at the moment.
Okay. Do we have any public comment on YouTube?
I had a question from Mary Worrell asking for a copy of one of the documents that we're looking at, so I just emailed her directly that document, but no substantive comments per se.
Okay. So at this point, if there's no public comment, I don't know if commissioners have any added comments based on, public comment that just came into the record, or if there are any, motions anybody would like to make.
Madam Chairman, to be clear on the motions, there's the motion to ratify the vote that you guys took to terminate the project. And is there a separate motion to send the letter to the select board? Is that how we're going to do that?
Yeah, so I think the letter to the select board sounds like it would come if we do not issue an enforcement order tonight, most likely based on the conversation from Jeff.
I think we need to meet with the selectmen anyway, so I'd make a motion to send the letter regardless of what the ultimate auction is tonight.
Okay. Is there a second to that? And we would have to amend the letter first to have some time constraints in there, I believe.
Mhm.
But is there a second to that at this point?
Will you allow further discussion?
Yes.
Seconded.
Yeah, for further discussion, if I may. I mean, I think I do agree with Linda's point that we need to meet with the select board either way. If the enforcement order is issued to remove, they're going to get a copy of it because they're a party to it. I think, but I think meeting to clarify our concerns is beneficial. And if we decide not to move forward with the enforcement order today, and we want to try to meet with them prior to a removal order, I think that's a separate motion. So I think in the motion, there needs to be a clarification on whether the option to send the letter is prior or post the issue of a removal order. Asking for that clarification.
Is that, Madam Chairman, would that be through my motion, my original motion?
It sounds like, yes, that's what Seth would be looking for.
Yes, please.
I would prefer it before you make the termination vote, but I don't know if there's enough votes for that. I'd like to send it either way, Seth. So it really depends on what the vote is on the termination. But I have another question, Madam Chairman, before I make that modification to my motion.
Yes, Linda.
If I made a motion instead to draft an order seeking sand compliance, would that be appropriate?
Yeah, I mean,
Forestall determination.
I guess you could make a motion that we would kind of amend the enforcement order, amend the enforcement order to be a compliance order instead, I believe. Jeff, am I correct on that?
Certainly, I mean, if one of the commissioners wanted to make a motion to draft an order to bring the structure back into compliance.
Oh, I lost your sound, Jeff.
Yeah, that was weird.
Am I
Twilight.
there?
Now you're there. Yeah.
Who knows? I was just gonna say, if someone made a motion asking to draft that order, I mean, obviously we would take those instructions. If someone wanted us to, even if one of the commissioners just asked us to draft an order that looked like that, we would effort to put that together for you guys to review if the board was interested as a whole.
That would be, I'd withdraw my first motion and make that motion.
Okay, can
I'll
you
deal
just,
with the letter separately.
okay, can you just clearly state the motion you're making so that it's in the minutes?
To draft an order of compliance. I have to wrote it down here. I gotta find it again. Modern technology is not my thing. Hold on. to make a motion to draft an order seeking sand compliance, bring it into compliance.
Okay. Thank you, Linda. Is there a second to that motion? Maureen, it looks like you have a question.
Thank you. I wish there was a queue we could put up. I think the multiple motions that have been made and discussed, it's getting a little confusing to me about what needs to happen first. And I apologize for perhaps seeming not to be, I think we should meet with the select board. But again, I would say, to my mind, the important thing is for us to have our own counsel before that meeting happens, because there are lots of there are a lot of issues that I think we need to be properly advised on, and we haven't been able to get that advice. So I would not be comfortable meeting with them until we get that advice. So I would want that to be part of whatever it is we decide. So I just wanted to make that clear. Thanks.
Madam Chairman, was there a second to my motion anywhere at all?
There has not been that I see, but Seth just put his hand up, so I'm not sure. When
Yeah, I guess this is a point of order. So it's my understanding that in order to do anything related to the original removal order, it would have to be a vote to amend that order. I don't think we can make a motion to have a separate order, since the vote to issue the enforcement order for removal has already been taken. And it's my understanding that a vote to amend that order would need to be done by someone who voted in favor of that order, but I'll defer to Jeff or maybe Terry, because I've been doing this less time than they have for sure.
Thank you, Seth, for that, because I believe you are correct about that reconsideration. Jeff?
No, I think Seth hit the nail on the head for some of that as well. So if you were going to change directions, someone would have to make a motion, apologize for this, to amend the existing instructions to do, and then to draft.
Oh, Jeff, we lost your sound again.
That is so weird.
I don't know why that is happening.
Now we hear you again. It like literally fades out to nothing.
All right, well, I'll try to talk louder and hopefully that's there. So yes, Seth was correct. I'll go short answer.
Okay. Thank you, Jeff. So it sounds like, Linda, that the motion that you made cannot be made at this point.
Well, then I'll go back to my original with the letter to the selectmen.
Okay.
Select board. I keep doing that.
Hold on. Ian has his hand up first.
I do. I think that first order of business is to address why this meeting has taken place, which is either to vote for or against the removal. And specifically, Maureen's point is I absolutely agree with. And as far as I know, under Robert's rules, Article 6, Section 36, it states that basically a reconsideration can be only made on the day, I quote, it can be made only on the day the vote to be reconsidered was taken, or a succeeding day if there's a legal holiday, which clearly isn't the case. And then in Article 6, Section 37, to rescind, repeal, or annul, which I would say is what we would have to do in this particular instance, that motion can be made by any member. So that's my non-legal 2 cents worth.
Madam Chairman, I wasn't asking to reconsider or reconsider your previous vote. I was simply, I guess, asking to amend that vote at this meeting, not reconsider, because that, we can't do that. It's not, he's right, it's not the same meeting. Just to
Excuse
amend
me,
the
if I may, Madam Chair, if I may, I say that we would have to rescind it before we could amend it.
Okay.
I'm not entirely sure that's correct, but I'll defer.
Okay. I think that the commission actually did order enforcement and removal on June 30th. So that does make it a little bit more difficult to amend with the sand mitigation component.
Okay.
Yeah.
Then I'll go back to my original motion then about sending the letter to the select board.
Okay. Seth, I think maybe has a comment or question first.
Yeah, I mean, I think the motion to send the letter to select board could be made, but it wouldn't, I guess, impact the process that we have at hand. We would still need to make a motion whether to issue the enforcement or the removal order or not, or actually not even whether to issue. We just need to vote on whether how we feel about that removal order. So I think that maybe I'll defer to Jeff in a second, but I think that in order to not do anything related to that motion to or order to remove the geotubes, that vote would either have to fail, or we would have to vote to rescind or repeal the prior vote.
Thank you, Seth. Jeff, I think you had clarification to that maybe.
Let's hope my audio works the whole time this time. So just really quickly, you could make a motion to send the letter to the select board, and then you obviously, you have that standing draft. You can simply continue that as an action and take a vote on a separate time. There's no statutory deadline that requires you to issue that out. If you're looking to get more information and you feel that that joint meeting will do that, you can certainly request that joint meeting, and you still have the pending removal order from 6:30 outstanding. And then after that meeting, if you decide to take action to order the removal, you certainly can, or you could also choose at that point to then, if you wanted to, you felt like you wanted to rescind that order and go a different direction, you could, but you don't lose the option either way through that process.
Thank you, Jeff. It looks like Mark has his hand up, and then Maureen, and then Seth.
I was just going to say thanks for the clarification about continuing.
So Mark, go ahead.
Yeah, I would suggest we send a letter to the Board of Selectmen and attach a additional sentence to it saying that we will schedule the vote on the order to remove on our next regularly scheduled meeting. So they have a week to get their act together and meet with us. And if they choose not to, they choose not to. So
Remember,
we
there's
will
a
not.
48-hour notice meeting. We're fine.
Yep. So thank you, Mark. I do worry that it's a little tight with the holiday, to do that. But I appreciate the time constraint, because I think it is very important that if we meet with the select board and delay the enforcement, that we meet within, the next 2 weeks at maximum. Jeff?
So if it's helpful for discussion purposes and to Mark's point, obviously our next meeting is next Thursday, the 9th, but our following meeting after that is September the 23rd. So it'll be 2 weeks after that date. And then the meeting after that is October 7th for our regularly scheduled meetings.
Thank you, Jeff. Maureen?
Once again, I would make a motion to send a letter to the select board saying that we believe that, something on the order of, it may well be a good idea to meet with you, but before we can do so, we believe we reiterate our request for outside counsel because of the far-reaching consequences of, these decisions. And the fact things just keep getting more and more complex. So,
Point of order, Madam Chairman. If
Yes,
that is meant to be a friendly amendment to my motion, I do not accept it.
right.
it was not meant, it was meant as a separate motion. I wasn't making a motion. I was suggesting that is what I think, if we're going to do anything, it should contain those things in it. That wasn't a formal motion.
All right, so I stand by my original motion, Madam Chairman.
Yes, to
And
issue.
if you want to do it what is that date is the 23rd, that second meeting of the month?
Yeah, I almost think though we should hold them to, I think the meeting with them should almost be by the 17th for then us to make our decision on the 23rd.
Right, I'll put that as part of my motion then.
Okay, so that's added to the motion. I know we have this motion hanging out there. Seth had his hand up. Ian, I saw your hand just come up. So we have a motion out there with still kind of discussion going on, which I realize is kind of confusing. Seth, do you have a comment, question?
Yeah, just quickly, if that motion was seconded and carried, would we continue this hearing to that date certain of the 23rd?
Yeah.
Jeff, I believe so, yes.
If you just give me 1 second, I think I can add the sentence that makes this clear to the letter that we looked at before, that hopefully addresses that. All right, so at the end of that letter that we looked at before, adding the sentence, the commission is requesting that this meeting take place prior to September 17th so that the commission may take action on this outstanding enforcement at the regularly scheduled meeting of the commission on September 23rd, 2021.
That's my motion, Madam Chairman.
Okay, thank you, Linda, for again working through this and all the clarifications. Ian, you maybe had a question, comment on this?
Well, I do, Madam Chair, and I wonder to what extent we're expressing a reluctance to actually put our signatures to an enforcement order, because you and I have both met with individual selectmen or select board members for several years on this subject. And as it's been so rightly pointed out, we have different purviews, and I don't see how meeting with them again is going to change our purview. And so I support. So I don't support this letter. I understand why people would like to have a compromise. I don't see how there can be a compromise. And I certainly would support opening a dialogue with selectmen as the select board going forward as the property owners after we voted on the enforcement order.
Mm-hmm.
Thank you, Ian. So again, Linda's motion is out there to issue this letter to the select board with the time deadlines on there of meeting before September 17th to continue this until this discussion, until September 23rd. Is there a second to her motion? Looks like not. no second. So that motion dies.
So does that mean we're not going to meet with the selectmen at all and not respect their request to meet with us? Is that what the upshot of this is, though?
Linda, I don't know.
I don't know what the upshot of that is, of not
Right.
going, sending the
I
letter.
think we realize that your opinion is very clear here. I don't think we're trying to be disrespectful in any way, but at this point, nobody is seconding your motion. Again, the select board was issued letters by us previously. So, there's a lot going on here, but I don't think it's a point of disrespect to continue down our process. But again,
But does that mean the letter's off the table? That's what I'm trying to figure out. That we're not sending any letter at all now, period? Is that where we've ended up? I just need to know.
So I know Maureen had, a discussion of a motion to include having our own legal counsel, prior to that meeting, which I would consider a different motion. So that might still be on the table should she wish to make it official. So that is still an option there.
My concern about that, Madam Chairman, is that the selectmen have been very clear. We are not getting independent counsel for this specific situation. And that means we would not meet with the select board at all if that's where we're going there, because they would never give us our own counsel. So that sort of leaves us in limbo land on the letter. Just the letter, regardless of what the restrictions are.
Right. So, maybe we draft a different letter for a different meeting about discussing, this stretch of Nantucket's resource areas to, plan going forward. I think we have many options and we can kind of leave those on the table. I know Maureen had her hand up and then Mark, I see your hand up.
So I am, there's, I wish this is where I really wish we could physically be together and kind of have a blackboard where we could write down, things that we're thinking of doing and kind of what a decision tree, could look like before we have to, commit ourselves. So we've all talked about being torn and I guess what I would do at this point, I would simply I would change my motion to simply say that before the Conservation Commission can respond to whatever the latest request is from the select board, that the Conservation Commission respectfully repeat its request for outside counsel so that we can be properly represented and the best and most fair solution, can come to the table. And so I think I am not against meeting with them. I am against meeting with them without having the benefit of counsel. So I'm making that motion to ask them for counsel in advance of meeting with them.
Thank you, Maureen, for that motion. I'm sure that would probably delay our timeline, but we can look at that. Ian, are you seconding the motion or do you have a comment? Because I think Mark has a comment maybe as well.
No, I'm not seconding the motion because I think it's the cart before the horse. So I certainly I would like to have a vote on the enforcement order and the amended orders and conditions, and then I would be happy to take a vote to respond to a motion along Maureen's lines. So thank you.
Thank you, Ian. Mark, I know your hand was up.
Yes, Madam Chair. We have a motion from Maureen, so I really shouldn't be. I was going to make another motion to issue the enforcement order, but Maureen is.
I'm willing to withdraw my motion.
Okay.
And I will so move, Madam Chair, to issue the enforcement order.
Okay. Ian?
I second.
Okay. So by roll vote, and again, this motion is to issue the enforcement order
As amended.
As amended.
as amended. By roll vote, Beal,
Aye.
Engelborg,
Aye.
Arisman, I, Golding,
Aye.
Phillips,
Aye.
Williams.
No,
Okay. So that motion carries with Commissioner Williams opposed.
Maureen, go.
And I now make a motion to write a respectful letter to the select board asking them to provide us with adequate counsel so that we can continue moving in the right direction for the good of the island.
And does that include a meeting with the select board as well?
Yes, that once we have hired counsel and have had an opportunity to consult with counsel, then absolutely a meeting with the select board to discuss the matters that we all would like to talk about.
Okay. Is there a second to Maureen's motion to issue a letter to the select board with the condition that we would have independent counsel appointed for us beforehand?
clarification, Madam Chairman, first.
Yes, Linda?
From what I gather from what was just said, that's on any issue or just this issue?
That would be on just on the Sconset Bluff
Yeah.
project.
That was not in the motion, so I'm just curious.
I'm
No.
sorry. I'm sorry, Linda. I thought it was clear from the context. It is clearly only for this and in other discussions. So it's obviously limited to that.
Okay, just needed it stated.
Okay. So thank you for your motion, Maureen. Is there a second?
Sure.
Seconded by Ian. So by roll vote, Beal,
Aye.
Engelborg,
No, and will you accept further discussion?
yes.
So if I'm in favor of sending a letter to the select board indicating what we're trying to do in terms of this process here, but I don't understand how the issue of having independent counsel and setting a meeting with the select board are related. So I'm opposed on that ground. I'm for sending the letter, but I don't understand how an independent counsel for a letter is needed. If it gets to a legal proceeding, it's a different issue, but we don't need a independent counsel to send a letter. We can just send a letter. So no.
Okay. Arisman, I, Golding,
Aye.
Phillips,
Aye.
Williams.
No,
So that carries with Commissioner Engelborg and Commissioner Williams opposed. So that leaves us, Mark?
Well, we do not need to do any continuing of this public hearing then, if that was on someone's mind. Is that correct?
Jeff?
So to be clear, this isn't a public hearing, Mark. This is a public meeting. It's not a hearing that was advertised or posted to a butters. It's an enforcement process. So there wouldn't need to be any continuing. So.
Thank you.
Seth?
Yeah, clarification on the motion that just carried. So if the select board says we don't grant you request to independent counsel, essentially, there's not going to be a meeting.
that was my question earlier. Yeah.
I want to have a meeting here. I mean, that's why I was opposed. I understand the desire to have independent counsel at that meeting, but I see those as being two separate motions. So that's why I voted no.
Same here.
Yeah, I mean, I see it both ways. I think because they have denied us counsel in the past, in order to meet with them, I think they need to kind of give us that counsel that we requested. So I see it both ways, Seth, that they could be separate motions, but I'm understand them together as well. But Seth, go ahead.
Yeah, that's fine. And the motion carried. So it's recorded at this point. But if we don't get any response from the select board and we end up not having a meeting, I guess I'm sort of prepared for that given the past history. But we've done our duty here with the enforcement order. So that's the number one most important thing. We'll see what the select board says in terms of a meeting, but I think tying those two things together is going to minimize their response, but that's how I see it.
No, Seth, I think there's definitely potential for that, but throughout this whole process, I've hoped that we could get our own counsel before we respond to the applicant, the property owner, kind of through this whole process. And we were kind of denied that legal support the whole time. So, I think that I would hope the select board would still want to have a discussion with us if they truly do want to discuss the issues on the bluff and move forward. But again, the ball is in their court on that one, to again appoint us counsel so that we can represent ourselves fairly. Maureen, I think I saw your hand maybe go up.
Yeah, I just wanted to say, and partly in response to you, Seth, I mean, this this isn't something that, is easily done or even thought about. I mean, it's really amazing or stunning to me that we are sitting here again, having to discuss this. But I think in order for us to do our job, we need the tools to do our job. And clearly, our select board and the SBPF have, to have another viewpoint, somebody might have different ideas as well. I just think we'll have a better solution if we have counsel. And that's my main reason for suggesting this, because we don't know what we don't know on some levels. And so that's why I think this is so important. And I hope very much that they don't see this as us, trying to, poison the well or something like that. This is us saying, good, and we'll all be there, on an equal footing. And I'm hoping that they will be able to see that, because I just don't see the downside to the process to our having counsel. I just don't see the downside. I think it will be helpful for us. So that's why I think it's so important. So
My hand is up as well, Madam Chairman.
Okay, go ahead, Linda.
I see that totally differently. I see it as us being adversarial, us not being on the same side as the powers that be. I see that as throwing down the gauntlet. I also see that as us trying to leverage a meeting with them, and we should meet with them because they asked. I know this has been going on for a while, but I think they're finally investing themselves in this issue with Baxter Road and the geotubes from their perspective and their jurisdiction and their goals and objectives. I think that's a mistake. I agree with Seth. I don't think they're the same thing. They've already said we're not getting counsel. There's no lawsuit against us between the board, the select board and the Concom. We're all again on the same side, working for the same community. And I don't think they'll do it. And I think tying it to that is creating a hostile situation that didn't need to exist. They've been very clear about this. And I think we need to keep the lines of communication open. And this would have been a good start to have a joint meeting to keep the lines of communication open. And it doesn't make us look better. It doesn't. If you look at what was in the newspaper today, the editorial, as well as some of the letters that were in the newspaper today about us not agreeing to even talk to them, there's different perspectives because we have ours in our jurisdiction, the selectmen have theirs, but to the public, where we're putting contingencies on having a meeting just to talk about where we are versus where they are and what our jurisdiction is versus their jurisdiction, and putting that caveat on there, that makes us look bad. And I'm really, really disappointed. There we go.
Linda, I appreciate that the newspaper is swayed. So, I try not to base our decisions off what things are being said in the newspaper. I don't see this as a gauntlet being thrown down. That we could flip that around and say that, the select board asking us to reconsider, not commenting on our letter, was them throwing something down. So I think we should avoid putting those sorts of kind of feelings behind our actions. I know that the commission, or the majority of the commission, has been looking for legal counsel on this issue really since June. And we were denied town council availability, and then we were denied our own counsel. So, that is definitely an issue. I think if people want to put, malice behind our decision, then that's their prerogative. But I don't think that's what's happening here. I think we genuinely want to work with the select board and make sure that they understand that we, deserve legal representation to look at this, and we want to have a conversation moving forward. I know I don't feel like this is throwing the gauntlet down. We're trying to meet with them, but we're asking for, counsel on this issue, and I think that's an appropriate request. But we can have a differing of opinion.
Did they deny us town council? I don't remember that. Was that before I came on, they denied town council? I haven't seen that since June. He was here.
I believe it was before you were on, but he did not attend some meetings that we should have had town council in attendance. So,
that's a problem.
Yeah. So, Ian, I think your hand was up, and then Seth, I saw your hand up.
You really basically, what you said, really, I'm in complete agreement. And I think that by asking us to reconsider and denying us counsel, that in other circumstances, that a property owner that behaved in that way would be taking the point of view of the applicant, i.e. SBPF. And I'm not saying that that is the case here, because I was not privy to their executive session, but this has been going on for many years. You and I have met with the select board over many years, and so I have nothing further to add, except that I think it would be very unfortunate if we ended up in an adversarial position with the select board. That is not the ultimate outcome that I would want, and I don't think it's an outcome that would be good for the island either. Thank you.
Thank you, Ian. Seth, you had your hand up.
Thank you, Madam Chair. I guess my whole point, if I haven't been clear enough, is what the purpose of the meeting with the select board will be. I think, I voted before to request independent counsel and help us drafting this enforcement order. But now that we've already drafted and issued that enforcement order, really what that meeting will be is a policy discussion. It's not going to change the outcome of any regulatory decision we've already made. It's a chance to have a hopefully friendly policy discussion about what we're doing and why, and how we can maybe avoid the situation in the future. If we had voted to continue this hearing and meet with the select board prior to issuing an enforcement order, I certainly would have said I wanted council to be there. But the order is already issued. It's going to be recorded, and our meeting isn't going to change that. Our meeting is really about what led up to this and what the policy moving forward is. And that's not something I think you need legal support for. That's a policy discussion. So that's how I see it. I certainly agree with what people are saying about us being denied independent legal counsel before. And that was unfortunate because we could have used that support in our regulatory decision making. But the decision making is done at this point. moving forward, the discussion is really just an informational discussion from how I see it. So that's where I'm coming from, but the motion made and carried, and I'm not going to say anything further on it.
Thank you, Seth. I, appreciate your perspective. I think, even if the town, say, denies us counsel and doesn't want to meet with us about this issue, we could still have further coastal policy discussions with the select board. Again, thinking larger than this, 900-foot section of bluff that we're kind of discussing tonight. Ian, you had your hand up?
Well, I did just sort of follow through with what Seth was saying. But my assumption was that if we met with the select board, that George Pucci would be present. And as such, then he would, as he made absolutely clear in his take it or leave it remarks, that he would be advising the select board and not the Conservation Commission. So I think that my support of Maureen's motion was predicated on that assumption. So thank you, Madam Chair.
Thank you, Ian. Is there any further discussion from commissioners? Or any questions? Jeff?
So just some bookkeeping for us. I'll have that form ready and sent out for digital signatures probably tomorrow morning sometime for the enforcement order. And then I'll have that letter that you've requested, Maureen, drafted for the meeting on Thursday.
Thank you, Jeff.
Thank you.
So at this point, if there are no further issues to discuss, is there a motion to adjourn?
I'll make that motion in another well-run meeting, Madam Chairman.
Oh, thank you, Linda. Is there a second? Seconded by Maureen. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Arisman, aye, Golding,
Aye.
Phillips,
Aye.
Williams.
Aye.
All right, that carries unanimously and the meeting is adjourned. Thank you, everybody, for your participation and attendance.
Thank you.